Good morning. My name is Mike Schwartz. I'm also a professor at Washburn. And I have the great honor of introducing Professor Amos Fiora of the University of Utah, S.J. Community College of Law. I've been carefully instructed by him to say as little as possible, and I will honor that request. I will mention that he happened to write books that have to do with the issues with which we're dealing these 2 days on counterterrorism and respect for human rights. He's also the author of a casebook on the subject, and he also has a very interesting background as a JAG for the Israeli Defense Forces. And so, with your kind permission, I will turn the floor over to Professor Amos Fiora.
Good morning. Can you all hear me in the back in the peanut gallery? I'm going to talk for the next few minutes about my proposal to establish domestic terror courts in the United States. This is one of those subjects that I invariably and inevitably get attacked from the left and from the right, which means that maybe there's something to it. I come to this from the following perspectives. Having spent 20 years of my career in the Israel Defense Forces and the Judge Advocate General Corps, I am deeply respectful about the limits of power, and I'm equally respectful about the needs to implement power. But I think the most important principle in the context of counterterrorism is that terrorists, or those who are suspected of being terrorists, have rights. And that if we forget for 1 minute, even for 1 second, that terrorists have rights, we will go right down that slippery slope, and not even Superman can get off that slippery slope. So where does that lead me to? Well, first of all, I think we need to be very careful in using terms. We're all talking about Gitmo. Well, the question is, are we talking about Guantanamo Bay, or are we talking about Gitmo? Those are two profoundly different assumptions. Being held as we speak here today in Guantanamo Bay are X hundreds of people. 500, 600, 250, whatever the number. That's Guantanamo Bay. But Gitmo refers to thousands upon thousands of post-9/11 detainees held directly or indirectly on behalf of the United States worldwide. There's a critical difference between X hundreds and X thousands. And I suggest that when we talk about Gitmo, in terms of what to do with these detainees, that we understand that we are talking about thousands of people who are in essence in legal limbo. What Dana Priest has referred to as the black sites, the black holes, but at the end of the day, they are in legal limbo. So, as we ask ourselves, how do we go forward? What do we do with these people? The question is whether or not the present legal or judicial system that is in place is relevant, applicable, and effective. And I would suggest that the answer is no. So in many ways, my talk should probably be defined as where do we go, how do we go forward? I suggest the following. The military commissions, for the reasons we've been talking about here, we can go on and on about the military commissions. But at the end of the day, I suggest, that to go forward with the military commissions is simply a non-starter. But, we can't say, okay, so let's close Guantanamo, let's close Gitmo. Because we have these thousands of people, and some of these thousands, some, are genuinely bad actors. Not all, some. So the first thing that has to happen is that we have to implement a criteria-based vetting process for determining which of these thousands of people presents today a viable threat to America's national security. Not who presented a threat yesterday, who presents a threat today, if not tomorrow. Once we've established this criteria-based vetting process, we're going to have a fork in the road. Those who do not present a threat to America's national security will go over here. Those who do will go over here. With respect to those who do not present a threat to America's national security, we need to implement very quickly some kind of a logistical process for dealing with their to-be release. The logistics of it are a logistical nightmare. There's no doubt about that. But I remind all of us of the words of the former president of the Israeli Supreme Court, Aaron Barak, who said that the logistical considerations of the executive are not to be a barrier for somebody's freedom. So we need to resolve that, and we need to resolve that very quickly. But those who, based on this criteria-based vetting, are deemed to be a true threat to America's national security, there are 4 different alternatives as to what to do with them. Before I get into all 4, I would suggest the following. None of them are perfect solutions. There is in this business of terrorism, counterterrorism, there is no perfect solution. So the question is, how do you minimize the bad? The 4 solutions, the 4 proposed solutions, or the 4 possible solutions are the following. 1, to continue with the military commissions. And I would suggest that of the 4 options, is probably the worst. For I think many of the reasons that are clear to many of us. Second option is to establish an international terror-based treaty court. Some of you will invariably and inevitably suggest, yes, that is a great idea. I say it's an interesting idea that has no chance whatsoever because the world cannot agree on what terrorism is. And as long as the world cannot agree on what terrorism is, there cannot be an international treaty-based terror court. The third alternative is Article 3 courts, simply to transfer them from Gitmo and put them in line, for instance, the United States District Courts, and to try them as if they were common criminals. I suggest that is also, with all due respect to Article 3 courts and, of course, to Article 3 judges, is also inapplicable and not going to be very workable. And so where does that lead me to? That leads me to the proposal that I put out there in a number of articles and interviews and op-eds, the establishment or creation of domestic terror courts for those individuals who are deemed to be viable threats to America's national security. How would this work? First of all, and before I give you the details, I'm the first one to say that there are constitutional difficulties with my proposal. So the best defense is a good offense, so I say to you that there are problems with my proposal. The court that will be created will be based on the FISA court. But in my proposal, I will turn the FISA court into a full court. It will be a court, trier of fact, without a jury, open to the public. Criminal evidence will be introduced just like in a criminal law process, with one exception. And the one exception is that intelligence-based information, based on sources, will be introduced in camera ex parte, not in the presence of the defendant and his attorney, meaning that on this particular issue, the introduction of classified information, the defendant will not have the right to cross-examine his accuser.